Most people who work in America have heard that they're an at-will employee. Most people think that when an employee is at will, the employer has carte blanche permission to fire them for any reason. And what is sad about this myth is a lot of good people who get fired under suspicious circumstances do a little bit of research and think, well, I was at will. I guess that means there's nothing that I can do. And that is incorrect. In this video, I will explain the AtWill Doctrine without all the legal gibberish, and I will show you when it matters and when it doesn't. My name is Branigan Robertson, and I'm an employment lawyer. Before we get into the details of this video, I have two quick orders of business. Number one, the amazing thing about YouTube is that we get to learn from each other. I would love to hear what you thought at-will employment meant before you watched this video. If my hunch is right, the vast majority of employees out there think that the at-will employment doctrine significantly limits their ability to use the legal system to their benefit. Number two, I will primarily discuss California law in this video because that is where I have a license to practice law. However, the at-will doctrine is fairly similar from state to state, so I've structured the information in this video to help everyone across America. Regardless, no matter where you work, you should not consider this video as legal advice. Internet videos are not advice. If you need legal advice, call a lawyer in your jurisdiction so he or she can hear your story and then give you advice. Now, if you worked in California and you believe the circumstances surrounding your termination are very suspicious, you can give my office a call for a free consultation if you feel like I've earned your phone call. All right. Let's get into it. Employers like to claim in job offer letters and employment documents that the at-will doctrine means that an employer can dismiss an at-will employee at any time for any reason with or without warning. Now, if you have something very similar to this in your employment documents, there's one part of that statement that is highly misleading, if not downright dishonest. And that is that an employer can fire you for any reason. That is wrong and not true. To flush this out, let's do a quick dive into what the law actually says, and I'll explain why this characterization of the at-will doctrine is wrong. All right, let's look at the law. California Labor Code Section 2922 is California's at-will statute. It says, an employment having no specified term may be terminated at the will of either party on notice to the other. Okay, what does that mean in plain English? This statute essentially does two things. Number one, it creates a legal presumption that your employment is at will, meaning unless you have a contract that says otherwise or that you can't be fired without cause, such as a collective bargaining agreement, you will be presumed to be an at-will employee. And number two, it is saying that either the employer or the employee can end the employment relationship without cause. This means that you, the employee, don't need a good reason to quit. You can just quit. If you don't want to work for someone, you don't have to. Similarly, the employer, with certain restrictions that we'll talk about in a minute, doesn't need to have a good reason to fire you. They can just fire you. Now, case law has further refined this statute. And it says a number of things, three of which the most important are, number one, that the employer's motive for termination and lack of care, therefore, are generally irrelevant. It is immaterial that the employer acted in bad faith or without cause. Secondly, the employer is not really required to treat all the employees exactly the same. The employer may act arbitrarily or inconsistently. Finally, the employer may act without being fair. They don't have to provide specific protections or fair procedures or even an objective evaluation. But even with all that said, being at will does not mean that the employer can fire you for any reason. That is wrong. But before we can cover what they can and can't fire you for, we need to look at the exceptions to the rule. Now, just because you're an employee in America, it doesn't automatically mean you're at will. At-will employment gradually became the default rule across the country, but some states still have slightly different rules. Over the 20th century, many states modified the rule by creating an increasing number of exceptions. Here are several of the common exceptions that we see as lawyers. Number one, employees in unions have collective bargaining agreements which usually have a just cause provision before they can fire you. Number two, employees who have written contracts with their employer requiring good cause for termination. Think professional athletes, high-level executives, or people with extremely valuable skill sets. These kind of folks can negotiate away the at-will doctrine and get a contract that guarantees a certain type of treatment during termination. Number three, employees who work for public entities, think city, state, or the federal government. Most public employees are protected by civil service laws and/or a collective bargaining agreement. Number four, employees of employers who say or do certain things that override the presumption of at-will employment. For example, let's say your boss sends you an email and says, "You definitely have a job here for the next 3 years." A written statement like that might be enough to remove your at-will employment status. All right, let's assume for the rest of the video that you don't fit into one of these exceptions, and you're definitely an at-will employee, which most people across America are. When can the employer fire you, and when can't they? The way most courts articulate it is that companies can fire at-will employees for any reason except for reasons that are unlawful. Let me repeat that. Companies can fire at-will employees for any reason as long as the reason is not illegal. Okay, what are the illegal reasons, Branigan? I'm glad you asked. I'm going to list the most common unlawful reasons for termination that lawyers like me see in our daily practice. Now, this list is not exhaustive, and you should look up your particular state's laws. But I think it's safe to say that it's unlawful to fire someone for the following reasons. And the good thing here is that I've made a video about each one of these subjects. So if you feel like you fit into one of these categories, I'll put a card up at one of the corners of the screen here, and you can click and go watch one of these videos to learn more about that subject. Number one, discrimination. This is where your boss fires you because of your race, color, religion, age, sex, pregnancy, national origin, or disability. Some states like California have even more protected categories like sexual orientation, ethnicity, veteran status, ancestry, marital status, gender identity, or military status. Number two, retaliation. This is where you complain about something protected by law and your boss fires you for making the complaint. This could be that you complained about an unsafe work environment, or you complained about unlawful discrimination or unlawful harassment, or you complained that you are being asked to break some sort of law. Number three, hostile work environment. This is where you're enduring a work environment that meets the legal definition of a hostile work environment. If you get fired in this environment, it might be illegal. Number four, leave of absence violations. This is where you get fired for taking a protected leave of absence, such as maternity leave or disability leave under FMLA. The company sometimes even fires people to avoid providing them with their lawful leave of absence. Number five, wrongful termination. This is a state case law rule that says it's unlawful to terminate someone for reasons that violate public policy. Generally, this is when a company fires you for doing something the state has specifically stated it wants companies to do, like follow the law. Number six, whistleblower violations. This is where you make a protected complaint to your boss or a government oversight agency and the company fires you. Now, obviously, there's a lot more, and each state has state-specific laws. So if you were fired and you feel that your termination is suspicious, I highly encourage you to reach out to a lawyer for a consultation. Many people see the at-will employment doctrine as unjust because of the inequality of bargaining power between the company and the employee. The company has all the power, and you need them for your paycheck. But it's not as unequal as most people think. In my opinion, the at-will employment doctrine is widely misunderstood. And if more people knew that it's really not a limiting factor, they may reach out to an attorney to see if they have a case. Now, if you have any questions about this video or things that I've said, please leave a comment down below. I try to answer most of the questions that people ask. If you found this video to be helpful, please go ahead and hit the like button. Finally, if you are in California and you feel that your termination is highly suspicious, I encourage you to call my office for a free consultation. That is all I have for you. I hope you have a fantastic day.